Continue. So remember there, Section 3 of the Bill of Rights, the right to privacy of communication and correspondence. Take note, the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. So I repeat, remember that this is among the provisions of the Bill of Rights governed by the exclusionary rule in evidence, so that any evidence obtained in violation of these will not be admissible for any purpose in any proceeding. Now, to strengthen this right, to bolster this right, Congress enacted Republic Act 4200, the Anti-Wiretapping Act. Okay, we have covered that one. Now, of course, we clarified this point already. What about the right of privacy? Is there really a right to privacy? Now, we discussed that one already, huh? What is the essence of the right to privacy? The right to be left alone. Okay, so Ople versus Torres, we actually adopted the Griswold versus Connecticut ruling of the U.S. Supreme Court that indeed there is a constitutional right to privacy, because it is not only expressly recognized in Section 3 of the Bill of Rights, there are even other facets of privacy enshrined in the various provisions of the Bill of Rights, like those in Sections 1, 2, 6, 8, and 17. In fact, there are even zones of privacy recognized and protected in our laws, like those in the Civil Code, those in the Revised Penal Code, and even in special penal laws, as well as in the Rules of Court on Privileged Communication. Settled na ngayon yan, ha? So be careful with that. Let us now consider freedom of expression. The relevant provision is Section 4. When we talk of freedom of expression, the relevant provision is Section 4. And if you read that provision, it states there that no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of a people peaceably to assemble and petition the government for redress of grievances. In other words, the particulars of that right, because that is a very broad freedom, under Section 4, apat yung binabanggit yan. Ano yan? Freedom of speech, then freedom of expression in particular, then freedom of the press, and yung freedom of assembly. The right of a people peaceably to assemble and petition the government for redress of grievances. Actually, to be included in this is Section 8. What is Section 8? Freedom of association. That is really part of freedom of expression, particularly freedom of assembly. Freedom of association, that should to be taken together with freedom of expression. Especially freedom of assembly. Remember that assembly presupposes the existence of an organized group. How can you assemble when you are alone? So that should be taken together with freedom of expression in Section 8. Also to be taken together with freedom of expression is Section 7. What right is that? The right of a people to information on matters of public concern. That should be taken together with freedom of expression, because for you to be able to express yourself well, it presupposes that you have access to information, especially information on matters of public concern. And remember that we are a democratic and republican state. And in a democratic and republican state, as we already clarified in the past, the general rule is disclosure of information, not secrecy. That's why in Section 7, you have there the right of a people to information on matters of public concern. Also, you have to consider Section 28 of Article 2, a very important state policy, the policy on transparency. So I repeat, when we take up freedom of expression, we will have to consider not only Section 4, but as well as Section 8 and Section 7. Now, this is a very important right. In fact, this is a preferred right. This is, remember that this is the hallmark of a democratic regime. Why? Any government that becomes undemocratic, the first will be victim of that undemocratic government will be freedom of expression. Historically, that had already been shown. Lahat ng naging diktador, ang unang kinontrol niyan yung press, yung media. Government, kinontrol yung media. Even in our own experience, when President Marcos proclaimed martial law on September 21, 1972, yung unang kinuha niya, yung media talaga eh. Sinara lahat ng dyaryo, patapos TV stations, kinuha ng gobyerno, they were taken over by the government. And there is only one government radio and TV station that was allowed to operate, the government radio and TV station. Tapos isang dyaryo rin lang ang pinayagang magpa-publish. Because you know, any government that becomes undemocratic, an undemocratic regime is intolerant of different views. In fact, it is afraid of different views. Unlike in a democratic regime, democratic government, what the policy is multiplicity of views, contending ideas, marketplace of ideas. Sabi nga ng Supreme Court in one case, the marketplace of ideas demands that the speech should be met by more speech, for it is the spark of opposite speech, the heat of colliding ideas that can fan the embers of truth. Take note of that. Preferred right yan eh. The crowning glory of a democratic regime is freedom of expression. An undemocratic regime is afraid of different views. It is intolerant of different views. In fact, in an undemocratic regime, in a dictatorship, kung pwede lang, bawal ka na mag-isip eh. Hindi ba? Uniformity of thought. After all, your big brother, the dictator, will think for you. That is an undemocratic regime. That is a dictatorship. Pero in a democratic regime, we are not afraid of different views, even unpopular views. Sabi nga eh, let 100 flowers bloom, let 1,000 schools of thought contend. The marketplace of ideas demands that the speech should be met by more speech, for it is the spark of opposite speech, the heat of colliding ideas that can fan the embers of truth. Okay, be guided by that. Now, as this freedom evolved, initially, when we talk of freedom of expression, initially, historically, in the United States, so in the Philippines, freedom of expression is limited only to freedom from censorship or prior restraint. Initially, that was how this evolved. In the United States as well as in the Philippines. Initially, when we talk of freedom of expression as understood, the protection extends only to freedom from censorship or prior restraint. The protection did not extend to freedom from subsequent punishment. That's why in the past, even in the United States, when they attained their independence from Great Britain, as understood then, yung freedom of expression is limited only to freedom from censorship or prior restraint. The protection did not extend to freedom from subsequent punishment. That's why even if you read American cases, during the earlier days, there were many who were punished for seditious libel. You know what is seditious libel? A libel against government and government officials. Because at that time, as understood, freedom of expression is limited only to freedom from censorship or prior restraint. The protection did not extend to freedom from subsequent punishment. It was only much later when this freedom truly blossomed, so that as now understood, when we talk of freedom of expression, the protection extends not only from freedom from punishment or from censorship or prior restraint, but it extends now to freedom from subsequent punishment. Because indeed, what is the use of allowing you to freely express yourself if after expressing yourself you'll be punished, you'll be penalized? It is only now that, I repeat, that this freedom truly blossomed. Because as understood now, the protection extends not only from censorship or prior restraint, freedom from censorship or prior restraint, the protection extends now to freedom from subsequent punishment. So as you can see, this is a preferred right, the crowning glory of a democratic regime. Preferred right, and that being the case, it is afforded the amplest protection among human rights in a democratic and republican setup. That you have to understand. However, take note, although this is a preferred right, but just like any other rights guaranteed in a Bill of Rights, this is not really absolute. In fact, there may be limitations imposed on this freedom. For instance, simply because we have our freedom of expression, are we free now to advocate the violent overthrow of government and government institutions and government authorities? Ibang usapan yan. Papasok yan ang question ng rebellion or sedition or inciting to rebellion, as the case may be. That is, there may be valid limitations imposed in our freedom of expression there. Similarly, simply because we have our freedom of expression, are we now free to malign the reputation of another person? Papasok na dyan yung question ng libel, slander, defamation. Those are felonies punishable under the revised penal code. Remember that your freedom of expression ends where the right to reputation of another person begins. Also, simply because we have freedom of expression, are we now free to produce, manufacture, distribute pornographic or obscene materials? Papasok yung question ng public morals. What about court proceedings? Are we free to comment on pending cases in court? Papasok diyan yung contempt saka yung sub judice rule. In other words, my point is that this may be a preferred right, but this is not really absolute. There may be valid limitations imposed in the exercise of this freedom. In other words, the freedom must be exercised with the corresponding responsibility. Do not forget that one. And because of that, we deal now with these limitations or restrictions on freedom of expression. First of all, let us consider the approaches adopted by the courts in dealing with freedom of expression. Now, I hope you still remember that one. What approaches were adopted by the court in dealing with freedom of expression cases? Initially, in the United States, likewise in the Philippines, the court in resolving questions involving freedom of expression adopted the dangerous tendency rule. The court adopted the dangerous tendency rule, so that under that rule, for as long as the speech, your speech, had a dangerous tendency of producing the substantive evil which the state is duty-bound to prevent or suppress, even if that substantive evil did not take place at all later on, justified na yung curtailment or suppression of their freedom of expression. Dangerous tendency rule. I repeat, under that rule, For as long as your speech had a dangerous tendency of producing the substantive evil which the state is duty-bound to prevent or suppress, even if that substantive evil did not take place at all later on, justified na yung curtailment or suppression of your freedom of expression. To illustrate, in the past, if somebody in a mass assembly, in a public rally, public demonstration, shouted, maghimagsik, magrevolusyon tayo, ibagsak ang korap at bulok na sistema, makiba ka, huwag matakot. Those are the usual slogans in public assemblies. Oh. Aarestuhin ka dyan, kakasuhan ko dyan, kukulong ka dyan. Justified? Can you claim, I am just exercising my freedom of expression, that's part of my freedom of expression? Under the dangerous tendency rule, hindi pwede yan. Justified yung curtailment or impairment of your freedom of expression. Why? Your speech, magrevolusyon, ibagsak ang korap na sistema, maghimagsik. Your speech is capable of producing the substantive evil which the state is duty-bound to prevent or suppress. What substantive evil? The resulting revolution. When there is revolution, there will be deaths, there will be injuries, there will be disturbance, not only disturbance to public peace and order, chaos. So as you can see, your speech, maghimagsik, ibagsak ang bulok na sistema, had a dangerous tendency of producing the substantive evil which the state is duty-bound to prevent or suppress. What is that substantive evil? The resulting himagsikan, the resulting revolution. Even if that substantive evil did not take place at all later on, it is enough that your speech had a dangerous tendency of producing that substantive evil, which will for the government to be justified in curtailing your freedom of expression. That was the situation then, not only in the Philippines, but even in the United States. Your speech had a dangerous tendency of producing the substantive evil which the state is duty-bound to prevent or suppress. Now, if you analyze that dangerous tendency rule, actually, the dangerous tendency rule leans heavily in favor of state power, in favor of public order, public peace, as against freedom of expression. It leans heavily in favor of state power. It leans heavily in favor of public peace, public order, public safety, as against freedom of expression. But then later on, as you know, so in the United States, as well as in the Philippines, the dangerous tendency rule had to be abandoned. And it gave way to the more libertarian rule. Now, what is that more libertarian rule? The clear and present danger rule. This is the more libertarian rule that superseded or replaced the dangerous tendency rule. This is now the rule applied in our jurisdiction. So that under this clear and present danger rule, for the government to justify the curtailment or suppression of your freedom of expression, it is not enough that the government is able to point out the substantive evil which the state is duty-bound to prevent or suppress, but that the substantive evil must be of a clear and present danger type. This is the clear and present danger rule. I repeat, under this clear and present danger rule adopted by the court, for the government to justify the curtailment or suppression of your freedom of expression, or freedom of the press for that matter, it is not enough that the government is able to point out the substantive evil which it is duty-bound to prevent or suppress, but that the substantive evil must be of a clear and present danger type. That's why, at present, you must have noticed this one. Have you seen a public assembly, a demonstration, a rally? Minjola, Plaza Miranda, Liwasang Bonifacio? Hindi ba yung mga salita, yung mga words of the speakers there, of the participants themselves, fiery, incendiary, provocative at times? Ano yung mga salitela? Magrevolusyon, ibagsak ang korap na gobyerno. Makiba ka, huwag matakot. Tapos sa mga pulis, mga pasista, mga tuta ni Gloria, di ba ganon? Provocative. Incendiary. Now, simply because the demonstrators, besides the demonstrations tend to be rowdy, unruly. Now, because of that, justified na ba yung i-disperse yung rally na yan, arestuhin yung mga speakers? Under the clear and present danger rule? No. Their speech may be capable of producing the substantive evil which the state is duty-bound to prevent, to suppress, but that the substantive evil is not of a clear and present danger type. You mean to say, if somebody in a public assembly or in a rally shouted at the top of his voice, mag-revolution tayo, you mean to say the whole people of the entire archipelago will take up arms spontaneously and overthrow the government and government authorities? Even the people of Metro Manila alone? Far from the truth. In other words, your speech may be capable of producing the substantive evil which the state is duty-bound to prevent or suppress, but that the substantive evil is not of a clear and present danger type. In the first place, sabi nga ng Supreme Court, what do you expect of speakers in a rally, in a public assembly? What do you expect of participants in a rally? Do you expect them to speak in polite language, courteous language? Huy, please, maghimagsik tayo, please. That is contrary to the nature of a public assembly. Pag sinabi yung public assembly, it tends to be unruly. It tends to be rowdy, passionate, incendiary mga speeches dyan. After all, hindi porke may nagsalita na mag-revolution, automatically, the whole people of Metro Manila will rise up in arms and overthrow legitimate authority. It's far from the truth. That is the clear and present danger. For as long as the demonstrators were unarmed, the rallies were unarmed, and they do not exhibit overt acts of violence, overt acts of disturbance of public peace and order, like destruction of property, hindi justified in dispersal niyan. Of course, ibang usapan kung yung participants in a rally, armado yan. Maski na paltik lang yan, ibang usapan na yan. O di kaya they exhibit overt acts of violence. Of course, a rally will cause inconvenience. Pero that is tolerable. It may cause inconvenience because those who are not participating in that rally will be inconvenienced dahil traffic will be affected. Hindi ba? The noise, di ba? Pero because of that, hindi justified yung curtailment or impairment of the freedom of expression. Hindi justified na i-disperse yung rally na yan, arestuhin yung mga participants, including their leaders. This is the clear and present danger rule. The more libertarian rule. So as you can see, if you compare the two, the dangerous tendency rule and the clear and present danger rule, the dangerous tendency rule leans heavily in favor of state power, state authority, whereas the clear and present danger rule is the exact opposite. It leans heavily on fundamental freedom, like freedom on the side of freedom expression. That's why sometimes this clear and present danger rule has been referred to as the more libertarian rule, as it leans heavily in favor of freedom of expression. Now, who formulated this clear and present danger rule? Hoy. Sige kayo, ha? You don't know your constitutional law, ha? Sino nag-formulate niyan? Justice Holmes. He was backed up there by Justice Justice Holmes, Brandeis. That's why this clear and present danger rule has been referred to as Holmesian in formulation. Holmesian, because it was Justice Holmes who formulated this clear and present danger rule. As I said, he was backed up there by Justice Brandeis. Now, what was the classic example given by Justice Holmes when he advocated this clear and present danger rule? Naku, talaga kinalimutan nila yung constitutional law nila. Ano ba yung classic example ni Justice Holmes? I'm sure you know that one. Hindi ba sinabi ni Justice Holmes, when you are inside a crowded movie house, and then you shouted, "Fire! Fire!" What will happen? Aristuin ka dyan. Sasabihin mo lang, I am just exercising my freedom of expression. Gago! Anong freedom of expression na magsisigaw ka ng sunog inside a crowded movie house? What will happen? Spontaneous, mangyayari, predictable, magkakagulo. There will be chaos, there may even be deaths or injuries or pandemonium. Ayan, justified yung suppression of your freedom of expression. Aristoy ka talaga dyan. Your speech is capable of producing the substantive evil which the state is duty-bound to prevent or suppress the resulting pandemonium, chaos, deaths, injuries. And the substantive evil, very imminent. Predictable, mangyayari yun. So that is the only time when ma-justify yung curtailment of your freedom of expression. That was the example given by Justice Holmes when he advocated this clear and present danger rule. Pero on the other hand, sabi niya, you are in the middle of an open field, sa gitna ng bukid. Sige, magsigaw ka na sunog dyan, maski kalabaw, hindi makikinig sa'yo dyan. But not inside a crowded movie house. Ibang usapan yan. Situational yan. You get the point? So you have there the clear and present danger rule, the more libertarian rule. This is now the rule observed in our jurisdiction. I repeat, under this clear and present danger rule, for the state to justify the curtailment or suppression of freedom of expression, it is not enough that the state is able to point out the substantive evil which it is duty-bound to prevent or suppress, but that the substantive evil must be of a clear and present danger type. Okay? And because of that, you must have noticed this one also. You must have observed this one in many of your readings of later cases. Even the presumption changed. Have you noticed that one? What is now the presumption? Any act of government that tends to impair or infringe upon freedom of expression and other constitutional rights, such an act comes to the court with a heavy presumption of unconstitutionality. Such an act comes to the court with a heavy presumption of unconstitutionality. So that the burden is now on the part of the government to justify that act. How will government justify that act? There are two requirements. Government must be able to point out to some compelling state interest, and that the measure is narrowly drawn to preclude abuses. Meaning to say, the measure is not overbroad. It does not suffer from the vice of vagueness. It is not unreasonable. That is now the presumption, and you have read that in several cases. Any act of government that tends to impair or infringe upon freedom of expression and other rights guaranteed in the Bill of Rights, such an act comes to the court with a heavy presumption of unconstitutionality. So that the burden now lies on the part of the government to justify that act. Now, how will government justify that act? There are two requirements. The government must be able to point out to some compelling state interest that will justify that act. But not only that, the measure must be narrowly drawn to preclude abuses, meaning to say, the measure is not overbroad, it does not suffer from the vice of vagueness, it is not unreasonable. That's why if you will recall that case, Reyes versus Bagaching, that old case when the mayor of Manila was still Mayor Bagaching, you have the anti-US basis coalition. They applied for a permit to hold a rally in front of the US Embassy to express their view that not everybody in the Philippines is happy with the continuing presence of American military base in the country. Ayaw mag-issue ng permit ni Mayor Bagaching. Ano sabi ng Supreme Court? Such an act of Mayor Bagaching of refusing to issue a permit to hold a rally by this group, such an act comes to the court with a heavy presumption of unconstitutionality, so that it is now incumbent upon Mayor Bagaching to show that indeed there will be violence that will take place if the rally is allowed to go on. It is not for the applicants for a permit to hold the rally to guarantee that the rally will be peaceful. It is not for them to guarantee that. It is up to the mayor who refused to issue that permit to show proof that indeed there will be violence. That's why he is denying that permit. Because such an act of Mayor Bagaching will impair such a fundamental freedom like freedom of expression. Such an act comes to the court with a heavy presumption of unconstitutionality, so that the burden now lies on the part of Mayor Bagaching to justify that act of refusing to issue the permit. It is not for the applicants to guarantee that their rally will be peaceful. It is for the mayor who refuses to issue the permit to prove that the rally will be attended by violence. That's why he is refusing to issue that permit. That is now the presumption. Any act of government that tends to impair or infringe upon freedom of expression and other freedoms guaranteed by the Bill of Rights, such an act comes to the court with a heavy presumption of unconstitutionality. So that the burden now lies on the part of the government to justify that act. Now, how will government justify that act? There are two requirements. The government must be able to point out to some compelling state interest. Second, that the measure is narrowly drawn to preclude abuses. Meaning to say, the measure is not overbroad, it does not suffer from the vice of vagueness, it is not unreasonable. Okay? That's why, because of that, let us consider now this case of Bayan versus Ermita. What case is that? Remember when the little girl was still there? Sunod-sunod yung mga rally sa kanya noon, di ba? And because of that, the Arroyo administration adopted the so-called CPR policy in dealing with rallies, demonstrations, mass actions. What does CPR mean? Calibrated Preemptive Response. Remember that under this CPR policy, in essence, strict enforcement of the no permit, no rally rule. Remember under Batas Pambansa bilang 880, what is Batas Pambansa bilang 880? The Public Assembly Act. Ay nako, kinalimutan na naman. Before one may hold a rally, or a demonstration, one must first secure a permit from the local authorities, the mayor, because you know very well what is the purpose of the permit. What is the purpose of a permit? Because when you hold a rally, what will happen? It will cause inconvenience to the others. Unang-una, traffic will be disrupted, di ba? Oh, what about those who are not participating in that rally? They will be caused inconvenience. In the first, that is why it is required under Batas Pambansa Bilang 880 that before one may hold a rally, one must first secure permit from the local authorities. Now, you see, the purpose of the permit is not to hold a rally per se, or not to criticize. For example, if you wanted to criticize the government or the policies of the government, kailangan bang, oy, Mayor Lim, apply ako for permit. I wanted to criticize the policies of Pinoy. No, it's not. You don't not need a permit to criticize the acts of government. That is part of your freedom of expression. The permit to hold this rally is regulatory. Because where will you hold the rally? In heaven? Of course no, in a public place. You will cause inconvenience to the others. Kaya ang purpose ng permit talaga regulatory. Now, ito naman, gusto naman ni GMA, strict enforcement of the no permit, no rally rule. Tapos sabing ganon, CPR policy. Okay, calibrated preemptive response policy. Kaya lang nag-backtrack din si Executive Secretary Ermita. Sabi niya, actually, the CPR policy is not different from the maximum tolerance policy defined under Batas Pambansa Bilang 880. Now, by the way, what is that maximum tolerance policy? Under Batas Pambansa Bilang 880, the Public Assembly Act, maximum tolerance is defined as the highest degree of restraint that the police, the military, the law enforcement officers must observe in dealing with rallies and public assemblies or in the dispersal thereof. Take note, that is the policy of the law. It is not just the high degree of restraint, but the highest degree of restraint that the police, the military, law enforcement officers must observe in dealing with rallies and public assemblies or even in the dispersal thereof. That is the policy of the law. Highest degree of restraint. So that the police should not be allow themselves to be provoked, because by the very nature of our public assembly, it tends to be very provocative. For as long as they do not display overt acts of violence and they are unarmed, they should allow to go on. Maximum tolerance in policy. Sabi naman yung Secretary Ermita in that case, actually this CPR policy, this is not different from the maximum tolerance as the policy as defined in Batas Pambansa Bilang 880. So no need to be alarmed about this CPR policy. O ano sabi ng Supreme Court? In that case of Bayan versus Ermita, if the CPR policy adopted by the Arroyo administration in dealing with rallies and public assemblies means no more than maximum tolerance as defined under Batas Pambansa Bilang 880, then it becomes superfluous. No need for that. That will only sow confusion. After all, the policy had already been defined by law. And what policy is that? Maximum tolerance. That becomes a superfluity. No need for that. However, if the CPR policy means more than maximum tolerance as defined by Batas Pambansa Bilang 880, then it becomes unconstitutional. If the CPR policy means more than maximum tolerance as defined by Batas Pambansa Bilang 880, then it becomes unconstitutional. That will constitute an infringement or impairment of freedom of expression and other basic freedoms. But if it means no more than maximum tolerance, then there is no need for that. Why adopt that? That will only cause confusion in the minds of the people. Bayan versus Ermita. Now, if you analyze, what is the orientation of Batas Pambasa Bilang 880? What is its orientation? The orientation is that we live in the era of the clear and present danger rule. It's as simple as that. That is the orientation of Batas Pambasa Bilang 880. We live in the era of the clear and present danger rule, so that the police, the law enforcement officers, they are mandated by law to observe maximum tolerance in dealing with rallies and public assemblies and mass actions, or even in the dispersal thereof. A recognition that we live in the era of the clear and present danger. You get the point? Yan talaga ang orientation ng Batas Pambasa Bilang 880. That's why it is in that law also, Batas Pambasa Bilang 880, and you might encounter this. What are the instances as defined by Batas Pambasa Bilang 880 when one may hold a rally even without permit from the local authorities? You better remember those. Ano yun? First, if the rally is to be held in a private place. For obvious reason, private place yan eh. Ang kailangan mo lang dyan, consent of the owner of the place. Second, if the rally is to be held in the campus of a state college or university, no need of securing permit from the mayor. All you have to do is coordinate with the authorities of that state college or university. What else? If the rally is to be held in a freedom park, and for that matter, all local governments were mandated by Batas Pambasa Bilang 880 to establish or designate a freedom park where people may hold a rally even without permit. Unfortunately, and the Supreme Court found it out in that case that walang nag-comply doon among the local governments. In fact, isa lang yung Cebu City, dinesignate yung Puente Osmeña as the Freedom Park. Manila, yung Sunken Garden, dinesignate as Freedom Park, pero sabi ng Supreme Court that had long been converted into a golf course. Because of that, nagalit ang Supreme Court. Sabi ng Supreme Court to compel these local governments to designate and establish freedom parks. Henceforth, one may hold a rally even without permit from the mayor. To compel them to comply with the mandate of the law. That was the mandate of the law. Batas Pambasa Bilang 880, they did not comply with that. Because of that, sabi ng Supreme Court, henceforth, unless they are able to establish or designate a freedom park where people may hold a rally even without permit, henceforth, one may hold a rally even without permit from the mayor. Kailangan lang mag-coordinate sa police because of regulation, traffic, etc. Now, by the way, under Batas Pambasa Bilang 880, kaya sabi ko yung orientation ng Batas Pambasa Bilang 880 is we live in the era of the clear and present danger rule. You apply for a permit to hold a rally before the mayor's office. If it intended to attend 2 days, your application is not acted upon, deemed granted yan. Deemed granted yan. Ang kailangan mo lang, yung kopya ng application mo na tinatakan receipt ng mayor's office, dala-dala mo. So that when you hold the rally, ipakikita mo sa police, ayan may application ako, hindi inaksyon ng mayor, deemed granted yan. Kailangan dala mo yun. Copy of the application to hold the rally. Duly marked by the office of the mayor that you filed for a petition. Deemed granted yan. That is because such an act of the mayor, following Reyes v. Bagaching, such an act of the mayor of refusing to issue a permit comes to the court with a heavy presumption of unconstitutionality. So, kung ayaw niya mag-issue ng permit, state niya kung bakit. It is not for the applicant to hold the rally to guarantee that the rally will be peaceful. It is up for the mayor who refuses to issue that permit to justify the refusal. Baliktad ang presumption you know that one Nabago yung presumption. If when we shifted from the dangerous tendency rule to the clear and present danger rule, even the presumption had to change. Okay? So take note of that, Now, because of this, the clear percentage, by the way, I repeat, baka magkamali pa kayo, the dangerous tendency rule had long been abandoned. Wala na yan. Baka magaya kayo kay Raul. Si Raul. Yes. Kung sinusundan mo yung pronouncements niya when he was still the Secretary of Justice, ano yun? Ang orientation kasi niya that we are still live in the era of the dangerous tendency rule. Kaya yung salita niya, puro ganun eh. Well, do not blame him. Palagay ko, naging abogado before the Second World War yan. Tapos, naging Jurassic Park na. Hindi na nakahabol sa developments. Na itong dangerous tendency rule, matagal nang inabandon yan. We live now in the era of the clear and present danger rule. Take note of that. Now, in connection with that, we'll have to deal with the so-called since we are dealing now with the clear and present danger rule, necessarily we'll have to deal with this. Content-based restrictions on freedom of expression, content-neutral restrictions. Now you must have noticed that both are actually restrictions on freedom of expression. Freedom of speech, freedom of the press, freedom of expression, these are restrictions. However, one is referred to as content-based, the other one is referred to as content-neutral. What is a content-based restriction on free speech? A restriction is said to be content-based if the restriction is directed against the speech itself or the contents of the speech. That is a content-based restriction. Actually, it is a content-based restriction is a gag. Sensorial in character. It is a prior restraint on freedom of expression. On the other hand, what is a content-neutral restriction? A content-neutral restriction, the restriction is not directed against the speech itself, but only on the incidents of the speech, the manner, the time, and the place of the speech. That is a content-neutral restriction. I repeat, the restriction is not directed against the speech itself, but only on the manner, the time, and the place of the speech, the incidents of the speech. To illustrate, a good case, Sanidad versus Comelec. You know what happened in that case? Just to illustrate the application of these the principles that we are discussing here, because it's important that you are able to visualize. In Sanidad versus Comelec, that was in connection with the plebiscite to ratify the Organic Act creating the autonomous region for the Cordilleras. During the campaign period in that plebiscite, the COMELEC issued a resolution prohibiting newspaper columnists, radio and television announcers and commentators In the case of newspaper columnists, they are prohibited from writing anything in their columns about the plebiscite issue, whether they are for or against the ratification of the Organic Act for creating the autonomous region for the Cordilleras. In the case of radio, TV announcers, and commentators, they are prohibited from making known their views on the subject in their radio show, radio programs, or TV shows. So there is a restriction there on freedom of expression of whom? Newspaper columnists, radio, TV announcers, and commentators. Now, what kind of restriction is that? Where is the restriction directed against? It is directed against the speech itself of the newspaper columnists, the radio, TV announcers, and commentators. They are prohibited from making known their views on the plebiscite issue, whether they are for or against the ratification of that Organic Act creating the autonomous region for the Cordilleras. As you can see, that is an example of a content-based restriction. If you analyze, the restriction is directed against the speech itself of these newspaper columnists, radio, TV announcers, and commentators. So, a content-based restriction actually is censorial in character. It is a gag. It constitutes a prior restraint on freedom of expression. Sanidad versus Comelec. But then let us go back to that case of Adjong versus Comelec. As I was saying earlier, in connection with the May 1992 elections, Adjong was a candidate for senator. At that time, bawal pa yung political ad ban law. So he cannot have his candidacy advertised in the media. So nagpagawa siya ngayon ng mga posters, stickers, decals, and other election campaign paraphernalia so that his candidacy can be disseminated to the voters. But then the Comelec issued that resolution prohibiting during the campaign period, during the campaign period, the posting of stickers, decals, posters, and other election campaign paraphernalia in public mobile places, except only in Comelec designated common poster areas. Now, if you'll analyze that Comelec resolution, pinagbabawal ba doon yung magpagawa ng poster or sticker si Adjong? Was that prohibited by that Comelec resolution? No. Pwede siya magpagawa ng posters, stickers, decals. Pinakikialaman ba ng resolution? Halimbawa, yung pinagawang poster, campaign poster ni Adjong, nilagay niya, instead yung mukha niya, yung batok niya. Hindi naman eh. Pwede ka magpagawa niyan. Halimbawa, pinalagay ni Adjong, do not vote for me. Pinakikialaman na ng resolution kung ano yung ilalagay niya sa posters niya? Hindi. Now, where is the restriction directed against? The time. During the campaign period, bawal mo ilagay yan. The place, where? Public mobile places. Doon mo lang pwede ilagay sa Comelec designated common poster areas. So what kind of restriction is that? Is the restriction directed against the speech? No. It is only directed at the incidence of the speech. The time, the place, the manner of the speech. Do you get the point? So, in Sanidad versus Comelec, definitely the restriction there is content-based. It is directed against the speech itself of newspaper columnists, radio, TV, announcers, commentators. Adjong versus Comelec, the restriction is not directed against the speech itself, but only on the incidence of the speech. The manner, the time, and the place of the speech. Okay? No. So you might ask, what is the significance of knowing the distinction? The significance of knowing the distinction lies in the application of the clear and present danger rule. As explained by the Supreme Court in Osmeña versus Comelec, If the restriction is content-based, remember that content-based restrictions are sensorial in character. They constitute a prior restraint on freedom of expression. For the government to justify that restriction, it is not enough that the government is able to point out the substantive evil which it is duty-bound to prevent or suppress, but that the substantive evil must be of a clear and present danger type. In other words, it is in content-based restrictions that you'll have to apply the clear and present danger test. On the other hand, if the restriction is merely content-neutral, for the government to justify that restriction, it is enough that it is able to point out the compelling state interest that will justify the restriction. No need of applying the content-based, or rather, the clear and present danger rule in content-neutral regulations. Because applying the clear and present danger rule in content-neutral restrictions is just like using a sledgehammer to drive a nail when all that is required is just an ordinary hammer. Those are the words of the Supreme Court in Osmeña v. Comelec. In other words, following that ruling, it is in content-based restrictions that you apply the clear and present danger rule, the clear and present danger test. But if the restriction is merely content-neutral, do not apply the clear and present danger rule in content-neutral regulations, because applying the clear and present danger rule in content-neutral restrictions is just like using a sledgehammer when all that is required is just an ordinary hammer to drive a nail, as explained by the Supreme Court in Osmeña v. Comelec. Now, do not, baka mamaya sabihin nyo, pag content-based, kailangan clear and present danger test. Pag content-neutral, dangerous tendency. That will be wrong. Yung dangerous tendency rule had long been abandoned. Wala na yan. Ang sinasabi lang, pag content-neutral yan, do not apply the clear and present danger rule. For the government to justify that restriction, it is enough that the government is able to point out the substantive evil which it is duty-bound to prevent or suppress. No need of applying there the clear and present danger test. Unlike content-based restrictions, which are really sensorial in character, they constitute a prior restraint on freedom of expression. Kaya to justify, kailangan it is not enough that the government is able to point out the substantive evil which is duty-bound to prevent or suppress, but that the substantive evil must be of a clear and present danger type. You get the point? Hoy! Sige kayo, ha? Sige. Now, in our cases, it is obvious, it's easy to detect whether the restriction is content-based or the restriction is content-neutral, di ba? Very easy. Like Sanidad, obviously that was content-based. Pero adjunct, obviously that was content-neutral. But that is not always the case. That is not always the case. There may be instances when it may be difficult for one to detect whether what is involved is content-based or content-neutral regulation. For instance, Reyes versus Bagaching. I repeat, know the facts of that case. That happened at a time when the RP-US military base agreement was still in effect. So there were American military bases in the Philippines. Subic, Clark, Kamchanhae. Now you have this anti-US bases coalition. Among them was the Venerable Justice J.B.L. Reyes. Nag-file ng application before the Office of Mayor Bagaching, Manila, for them to be allowed to hold a rally in front of the U.S. Embassy, so that they will let their views be known by the American public and the American policy makers and by the American government that not everybody in the Philippines was happy with the continuing presence of American military bases here. Yun ang application nila, to hold the rally in front of the U.S. Embassy. Sabi ni Mayor Bagaching, ayaw kong mag-issue, magkakagulo kayo. papasukin kayo ng infiltrators. There will be violence. I refuse. Kaya lang, tingnan mo alternativa, sabi ni Mayor Bagatsing, but if you agree to transfer the venue of the rally from in front of the U.S. Embassy, you will hold it at Liwasang Bonifacio. You know Liwasang Bonifacio? Okay. I will issue a permit. In fact, sabi ni Mayor Bagatsing, bibigyan ko pa kayo ng personal security ko to see to it that there will be no infiltrators. So, there is a restriction on freedom of expression there. Ayaw kong mag-issue ng permit. But if you agree to hold the rally in front, instead of in front of the U.S. Embassy, you will hold it at Liwasang Bonifacio, I will issue. Bibigyan ko pa kayo ng personal security ko. So that the rally will be peaceful. Hindi kayo papasukin ng mga infiltrators. Now tell me, what kind of restriction is that? Ayaw niya mag-issue ng permit, pero nag-offer siya ng alternative site. Was the restriction content-based or content-neutral? Hoy, you better make up your minds. You don't have the luxury of time. Content-based or content-neutral? It may appear to be content-neutral. Kasi parang nire-regulate yung the time, the place of the... But upon closer scrutiny, that's content-based. That's content-based. Sino ba ang magrarally? Anti-US basis coalition. Ano ba yung message nila? Yung message nila, tsaka kanino nila dinadirect yung message nila? Is it to the Filipino people? No. To the American policymakers, American government, American people. That is their message. They wanted it to be known to the American people, to the American policymakers, to the American government that not everybody in the Philippines is happy with the continuing presence of American military bases here. That is their message. If you will transfer the venue of the rally doon sa Liwasang Bonifacio, you think the embassy people will care? What is the best place to express their view? In front of the U.S. Embassy. That is because their message, you have to remember, their message is not directed to the Filipino people. It's not even directed to the Philippine government. It is directed to the American government. If you will hold a rally in front of the U.S. Embassy, sigurado imo-monitor yon ng U.S. Embassy. Hindi lang U.S. Embassy, pati CIA. So yung message nila, abot talaga sa policymakers. Abot pa nga sa American people. Pero i-transform mo sa Liwasang Bonifacio, you think the embassy people will care? So as you can see, at first glance, the restriction may appear to be content neutral, but actually, that was a content-based. Kaya nga, in resolving that case, anong ginamit ng Supreme Court? Clear and present danger test. Any act of government that is alleged to have infringed upon a constitutional right like freedom of expression, such an act comes to the court with a heavy presumption of unconstitutionality. So it is up to Mayor Bagatsing, who refuses to issue the permit, to show proof that there will be violence. It is not up for the applicants to guarantee that the rally will be peaceful. Ginamit talaga ron, clear and present danger test eh. That is because the restriction is really, although it may appear initially to be content neutral, pero actually content-based yun. Kaya in resolving that issue, in ruling against the act of Mayor Bagatsing, in-apply ng Supreme Court yung clear and present danger test. Get the point? Now, batas pamasa bilang 880, the Public Assembly Act. Ano yan? Content-based or content-neutral? Ayan, sabi ng Supreme Court sa Bayan vs. Ermita, content-neutral yan. The purpose of the permit is regulatory lang. Because when you hold a rally, you will cause inconvenience to others. Regulatory lang yan. That is not content-based. That is merely content-neutral. Get the point? So there you are. And because of that, actually, we have to deal with the so-called O'Brien test. United States versus O'Brien. This is the most, sabi nga ng Supreme Court natin, this is so far the most influential test for distinguishing content-based from content-neutral regulations. The most influential test for distinguishing content-based from content-neutral regulation. And it is said to have become canonical in the review of such laws. It is noteworthy that the O'Brien test has been applied by this court in at least 2 cases. Adjong versus Comelec, Osmeña versus Comelec. Ginamit talaga yung O'Brien test. The most influential test in determining or in distinguishing content-based from content-neutral regulations. So what is this O'Brien test? Under this O'Brien test, SWS versus Comelec and bank ruling, a governmental regulation is sufficiently justified, 1, if it is within the constitutional power of the government, 2, if it furthers an important or substantial governmental interest, 3, if the governmental interest is unrelated to the suppression of free expression, 4, if the incidental restriction on alleged First Amendment freedoms of speech, expression, and press is no greater than is essential to the furtherance of that interest. So that is the O'Brien test. I repeat, a governmental regulation is sufficiently justified, 1, if it is within the constitutional power of the government, 2, if it furthers an important or substantial governmental interest, 3, if the governmental interest is unrelated to the suppression of free expression, 4, if the incidental restriction on alleged First Amendment freedoms. What are the First Amendment freedoms? Freedom of speech, expression of the press, is no greater than is essential to the furtherance of that interest. Okay? So be guided by that. Baka lang ma-encounter nyo yung O'Brien test. Just remember that this is the most influential test for distinguishing content-based restrictions from content-neutral regulations. Okay, so there you are, So much with that. Now let us consider now another area here. Freedom of expression versus libel, slander, defamation. As I was saying, remember, simply because we have our freedom of expression so that we are now free to malign or destroy the reputation of another person, papasok na yung question ng libel, slander, defamation. Di ba? Oy. Now remember that these are felonies under the revised penal code. Libel, slander, defamation. Now, first of all, what is a good defense in an action for libel, slander, defamation. What is a good defense? Privileged communication. Nakalimutan na naman nila. Privileged communication. In the first place, remember, truth is not a defense in action for libel or slander or defamation. It is not a defense. So that even if your statement, if your alleged defamatory imputation happens to be true, for as long as you have no justifiable motive in spreading that or circulating that, pwede kang mapinahan dyan. Truth is not a defense in action for libel or slander or defamation. What is a good defense? If the alleged defamatory imputation actually is a privileged communication. Why? Because remember, as you have taken this up in your revised penal code, in an action for libel, slander, defamation, the presumption of actual malice applies. So that a plaintiff or complainant in action for libel, slander, defamation need not prove actual malice. Implied na yan. Ang kailangan niyang i-prove, you had that defamatory statement published or circulated. Pag na-prove na niya yan, presume na yung actual malice. The presumption of actual malice applies. So pwede kang mapinahan dyan. Ang ipoprove lang niya is that you have the alleged defamatory imputation published or circulated. Okay? Now, but if the alleged defamatory imputation is actually a privileged communication, the presumption of actual malice will not apply. That's why a complainant or plaintiff in action for libel, slander, defamation will have to prove actual malice. Now, how will he prove actual malice? Mahirap yan. How will he prove actual malice? Napakahirap yan. That's why, sabi nga, a good defense in action for libel or slander or defamation is if the alleged defamatory imputation is actually covered by a privileged communication, because the presumption of actual malice will not apply in that case. So that the plaintiff or complainant in action for libel, slander, or defamation will have to prove actual malice. How will he prove that? Mahirap. Now, however, now, take note, when we talk of privileged communications, generally, they are of two types. Ano yun? An absolutely privileged communication or a qualifiedly privileged communication. These are the two types of privileged communications. An absolutely privileged communication, saka yung isa, qualifiedly privileged communication. Now, sabi ng Supreme Court in Borjal vs. Court of Appeals, absolutely privileged communication are those which are not actionable even if the author acted in bad faith. And a good example is that is found in Section 11, Article 6 of the Constitution. Ano yun? The freedom of speech and debate of members of Congress. No member shall be questioned or be held liable in any other place for any speech or debate in the Congress or in any committee thereof. That is an example of an absolutely privileged communication and therefore not actionable even if the author acted in bad faith. Okay? Now, on the other hand, qualifiedly privileged communications containing defamatory imputations are not actionable unless found to have been made without good intention or justifiable motive. I repeat, qualifiedly privileged communications containing defamatory imputations are not actionable unless found to have been made without good intention or justifiable motive. Borjal vs. Court of Appeals. Now, what is an example or examples of qualifiedly privileged communications? Examples of those are those found in Article 354 of the Revised Penal Code. If you look at Article 354 of the Revised Penal Code, there are two privileged communications there. Private communications, saka fair and true report without any comments or remarks. Those are qualifiedly privileged communications, not actionable, unless found to have been made without good intention or justifiable motive. Now, interesting question, Borjal vs. Court of Appeals. Ito bang enumeration of privileged communication under Article 354 is not exclusive? Sabi ng Supreme Court that is not exclusive. Mayroon pang isa dyan. Ano yun? Yung doctrine of fair comment. That is because of freedom of expression. In other words, the significance of this ruling in Borjal vs. Court of Appeals is that the Supreme Court for the first time clarified that the enumeration of qualifiedly privileged communications under Article 354 of the Revised Penal Code, that is not exclusive. Mayroon pang isa. And that is because of freedom of expression. Ano yun? Doctrine of fair comment. So what is that doctrine of fair comment? As held in Borjal vs. Court of Appeals. Sabi ng Supreme Court, fair commentaries on matters of public interest are privileged and constitute a valid defense in action for libel or slander. Now, the doctrine of fair comment means that while in general every discreditable imputation publicly made is deemed false because every man is presumed innocent until his guilt is judicially proved, and every false imputation is deemed malicious. Nevertheless, when the discreditable imputation is directed against a public person in his public capacity, it is not necessarily actionable. When the discreditable imputation is directed against a public person in his public capacity, it is not necessarily actionable. In order that such discreditable imputation by a public official may be actionable, it must either be a false allegation of fact or a comment based on a false supposition. If the comment is an expression of opinion based on established facts, then it is immaterial that the opinion happens to be mistaken as long as it might reasonably be inferred from the facts. So I repeat, Borjal vs. Court of Appeals, sabi ng Supreme Court, the doctrine of fair comment means that while in general, every discreditable imputation publicly made is deemed false because every man is presumed innocent until his guilt is judicially proved, and every false imputation is deemed malicious. Nevertheless, when the discreditable imputation is directed against a public person in his public capacity, it is not necessarily actionable. Take note of that. When the discreditable imputation is directed against a public person in his public capacity, it is not necessarily actionable. In order that such discreditable imputation to a public official may be actionable, it must either be a false allegation of fact or a comment based on a false supposition. It must either be a false allegation of fact or a comment based on a false supposition. If the comment is an expression of opinion based on established facts, then it is immaterial that the opinion happens to be mistaken, as long as it might reasonably be inferred from the facts. Okay? Now, that's why you have that later case, very interesting case. Vasquez versus Court of Appeals. You still remember that case? You have the residents of Tondo, Manila. Meron silang community newsletter. Yung dyaryo nila, naka-mimeograph kan lang. Community newsletter nga eh. Hoy! Gising pa ba itong mga to? Meron silang community newsletter. Yung mga mimeograph form lang. Nilagay nila sa dyaryo nila, Headline! Ang aming barangay kapitan, magnanakaw ng manok. Headline! Community newsletter. Imagine that one. Ang aming barangay kapitan, magnanakaw ng manok. Binweltahan sila ng kapitan na nag-file ng libel case against them in the RTC. Convicted on appeal, Supreme Court. Judgment of conviction reversed. In-apply ng Supreme Court yung doctrine of fair comment. Remember, he is a punong barangay. Public figure yan. Public official yan. In order that such discreditable imputation to a public official may be actionable, it must either be a false allegation of fact or a comment based on a false supposition. If the comment is an expression of opinion based on established facts, then it is immaterial that the opinion happens to be mistaken as long as it might reasonably be inferred from the facts. Ano yung headline? Ang aming barangay kapitan magnanakaw ng manok. What is that? That is an expression of opinion. Hindi ba? That is an expression of opinion. Now, based on established facts, sabi ng Supreme Court in that case. Why? Kasi, totoo naman talaga na yung barangay kapitala, kinasuhan sa piskalya pagnanakaw ng manok. Yung fighting cocks ito yung mga sasabungin. Although dinismiss ng piskalya. If the comment is an expression of opinion based on established facts, ano established facts? Talaga naman kinasuhan siya ng pagnanakaw ng manok sa piskalya, kaya lang dinismiss. Then it is immaterial that the opinion happens to be mistaken as long as it might reasonably be inferred from the facts. That is an expression of opinion based on established facts. Kaya lang mali, kasi dinismiss din ng piskal yung kasong pagnanakaw ng manok. If the comment is an expression of opinion based on established facts, what was the established facts? Talaga naman kinasuhan sa piskalya ng pagnanakaw ng manok yung kapitan Then it is immaterial that the opinion happens to be mistaken as long as it might reasonably be inferred from the facts. So judgment of conviction reversed on reasonable doubt, acquitted. Vasquez v. Court of Appeals. But as you can see there, application of the doctrine of fair comment. This may be invoked is what is involved is a public figure in his public capacity. Now, all of us will qualify under that term public figure. All of us. Why? Look at the definition. Well, how did the court define a public figure? Borjal, citing Ayers Production versus Judge Capulong. Sabi ng Supreme Court, who is a public figure? A person who, by his accomplishments, fame, mode of living, or by adopting a profession or calling which gives the public a legitimate interest in his doings, his affairs, and his character, has become a public personage. He is, in other words, a celebrity. Obviously, to be included in this category are those who have achieved some degree of reputation by appearing before the public, as in the case of an actor, a professional baseball player, a pugilist. Ano yung pugilist? Manny Pacquiao, boksingero, or any other entertainer. The list, however, is broader than this. The list, however, is broader than this. It includes public officers, famous inventors and explorers, war heroes, and even ordinary soldiers, infant prodigy, and no less a personage than the great exalted ruler of the lodge. It includes, in short, anyone who has arrived at a position where the public attention is focused upon him as a person. So pasok tayong lahat dyan. You have arrived at a position where the public attention is focused upon you as a person. Why? Magte-take kayo ng bar, ipapublish ang Supreme Court, aabangan ng tao yan. Oy, baka akala nyo ordinary mortals kayo. You have become a public figure now. So pwede ka nang i-libel, pwede ka nang magnanakaw ng manok. You have become a public figure. It includes, in short, anyone who's arrived at a position where the public attention is focused upon him as a person. You have arrived at such a position where the public attention is focused upon you as a person. Kaya pag-file mo ng petition to take the bar examinations, ipapublish ng Supreme Court, nakaabang doon. Ay, naku, may magpa-file ng petition. I was abandoned by naku, yung may mga sabit yan, ha? Yung mga baka mamaya habulin kayo, nagkaanak kayo dyan sa ano, ha? Yan ang pagkakataon. That is the purpose of the why your name is being published. No. Wala, sige kayo. Public figure na kayo. You are no longer ordinary mortals. So, pag nilibel kayo or slander, defamation, since you are a public figure, ay nako, may depensa na, kakasuhan mo nag-libel sa'yo o nag-defame sa'yo. Slander, defamation, mayroon siyang defense. He is a public figure, defense, doctrine of fair comment. He is a public figure. In order that such discreditable imputation to a public official may be actionable, it must either be a false allegation of fact or a comment based on a false supposition. If the comment is an expression of opinion based on established facts, then it is immaterial that the opinion happens to be mistaken as long as it might reasonably be inferred from the facts. So remember Vasquez versus Court of Appeals. Ang aming barangay kapitan magnanakaw ng manok. That is an expression of opinion based on established facts. What was the established fact? Talaga naman kinasawa ng pagnanakaw ng manok sa piskalya. Kaya lang dinismiss. It is immaterial that opinion happens to be mistaken as long as it might reasonably be inferred from the facts. Patay kang bata ka. Okay? Now, what is the reason behind? Actually, itong doctrine of fair comment, sino natin again yung American jurisprudence dito. The American case, New York Times versus Sullivan. Now, what was the reason behind that New York Times ruling? Sabi ng Supreme Court, the guarantees of freedom of speech and the press prohibit a public official or public figure from recovering damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with actual malice. Unless he proves that the statement was made with actual malice, meaning to say, with knowledge that it was false or with reckless disregard of whether it was false or not. The raison d'etre for the New York Times doctrine, was that to require critics of official conduct to guarantee the truth of all their factual assertions on pain of liable judgments that would lead to self-censorship. Since would-be critics would be deterred from voicing out their criticisms even if such were believed to be true or were in fact true because of doubt whether it could be proved or because of fear of the expense of having to prove it. So that is the reason behind that. I repeat, the raison d'etre for the New York Times doctrine was that to require critics of official conduct to guarantee the truth of all their factual assertions on pain of liable judgments that would lead to self-censorship. Since would-be critics would be deterred from voicing out their criticisms, even if such were believed to be true or were in fact true, because of doubt whether it could be proved or because of fear of the expense of having to prove it. That's the reason why the American Supreme Court adopted this doctrine of fair comment in the case of New York Times versus Sullivan. Okay? So, medyo tingnan niyo yung yung development na yan, yung doctrine of fair comment. So, I repeat, as held by the Supreme Court in Borjal versus Court of Appeals, the enumeration of the qualifiedly privileged communications under Article 354 of the Revised Penal Code, dalawa yun, that is not exclusive. Mayroon pang isa, yung doctrine of fair comment. Because of freedom of expression. This doctrine of fair comment, New York Times versus Sullivan ruling of the U.S. Supreme Court. A development in this area. Okay? So take note of that. Now, as I said, kasama rin sa Article 4 yung freedom of assembly. Freedom of assembly. Now, in connection with that, i-correlate natin sa Section 8, Freedom of Association, di ba? Now, Freedom of Association, Section 8, this is available not only to those employed in the private sector, but as well as to those employed in the government sector, di ba? The right of the people, including those employed in public and private sectors, to form unions, associations, or societies for purposes not contrary to law, which shall not be abridged. Okay? Shall not be abridged. Now, so this is available not only to employees or workers in the private sector, but even to government employees. Now, kaya lang, do not forget, who among the government employees are not allowed to join or form unions? Executive Order number 180. Bakit nalimutan nyo, your labor law? Ano? Members of the armed forces, policemen, firemen, jail guards. Bawal yan mag-union sila, bawal sila sumali sa union. For obvious reason. Why? These are the armed elements of the state. Members of the armed forces, policemen, firemen, jail guards, these are the armed elements of the state. Pag unionin mo niya yung mga yan, sobra pa sa kudeta abutin din dyan. So do not forget, Executive Order number 180. Among the government's employees, yung apat na yon, hindi pwedeng mag-union, hindi pwedeng mag-organize. Okay? Now, other than pwede. The right to form unions, pwede yan. That is available not only to those employed in the private sector, but as well as to government employees. Kaya lang, yung right to strike. Government workers, though they also have the right to strike, ibang usapan yan. No question about that. They can form unions, but they have no right to strike. You still remember, SSS, Employee Association versus SSS, di ba? Unlike their counterparts in the private sector, who are not only allowed to form unions or join unions, they are even allowed to strike. Now, what is the reason for that? You better know that one. You took that up in your labor law. Why is it that the government workers are not allowed to strike, unlike their counterparts in the private sector? Again? Why are they not allowed to strike? Yes. Ano? Bakit public interest? You mean to say, pag nag-strike ang mga taga-Meralco, public service will not be disrupted? Private yan? Or yung mga empleyado ng PLDT? Private yan. Lalo na yung mga workers ng San Miguel. Ang daming maapektuhan yan. Yung may mga Saya, yung mga may, di ba? Alcohol content, mababawasan. Several days, kung mag-strike mga taga San Miguel, tsaka our sisters in the beer houses, di ba? Yan lang hanap buhay nila, commission doon sa beer. Oy, don't tell me na pag private sector, hindi apektado yung public welfare. Ano talaga ang real reason? Yung sinasabi mo, the terms and conditions of employment. You better remember that one. Those in the private sector, the terms and conditions of their employment are governed by contracts. Whereas those in the government sector, the terms and conditions of their employment are governed by law. Magkaiba yan. Those in the private sector, the terms and conditions of their employment are governed by contract. And remember that strike is the best weapon that the workers in the private sector may employ to compel their employers to sit down with them in collective bargaining talks. Deny them the right to strike, no employer will be foolish enough to sit down with their workers in collective bargaining talks to improve the terms and conditions of employment of their workers. That is the reason there. What about those in the government sector? The terms and conditions of their employment are governed by law. After all, even if you allow them to strike, may magagawa ba yung mga boss nila? Wala. Legislated act yan eh. Congress ang pwede mag-change ng terms and conditions of employment of those in the government service, especially with this salary standardization law. Wala rin magagawa yung mga boss nila. Halimbawa, yung mga taga-BIR o mga taga-Department of Agriculture, pag-strike mo yan, bakit may magagawa ba yung Secretary of Agriculture or Secretary of Finance? Ma-improve ba yung terms and conditions of their employment? Ma-increase ba yung sweldo nila? Hindi. Kasi legislated act yan, kongreso yan eh. That is the reason, as you know very well, nagkakatalo yan sa terms and conditions of their employment. Those in the private sector, the terms and conditions of their employment are governed by contract, and the strike is the most potent weapon that workers in the private sector may employ to compel their employers to sit down with them in collective bargaining talks so that their terms and conditions of their employment will be improved. But in those in the government sector, the terms and conditions of their employment are governed by law. That's why they are not allowed to strike. Aside from the fact, of course, that if they allow them to strike, that will disrupt public service. The delivery of public services will be tremendously affected. Okay? So, ingatan nyo yan. Kaya lang, ito na ngayon ang twist. Jacinto versus Court of Appeals. Ito, ingatan nito yung area ito, ha? 1990, public school teachers in Manila, they walked out of their regular classes. They refused to return to class notwithstanding the order from their superior, the DEX. You know the DEX? At that time, DEX pa. Ano yun? Department of Education, Commerce, and Sports, di ba? Education, Commerce, Sports. Kasi yung mga teacher nagtitinda ng longganisa, ng chichirya, di ba? Sa liit ng sweldo, kaya commerce nga eh. Anyway, wala na yun. Ngayon, DepEd na, di ba? DepEd na, okay. At that time, DEX pa. So they walked out of their classes during regular class hours. They refused to return to class, notwithstanding the order from the DEX, their superior. Because of that, they were charged admissively, and several of them were removed from the service. Because of that, nag-file sila ng petition in the Supreme Court. They questioned the dismissal. Now, first of all, take note, you better be keen on this. They denied that they engaged in strike. Sabi nila, alam naman namin, bawal mag-strike ang mga government employees. What we merely exercise is a constitutional right. The right to peaceably assemble and petition the government for redress of grievances. How come when we exercise a constitutional right, we were punished, we were dismissed from the service? You see the twist in the argument? They denied that they engaged in strike. Sabi lang ganun, we merely exercise a constitutional right. Section 4, the right to peaceably assemble and petition the government for redress of grievances. How come when we exercise a constitutional right, we were punished, we were dismissed? Now, anong sabi ng Supreme Court? In the first place, sabi ng Supreme Court, what you did was a strike. It falls within the meaning of the word strike under the labor code. That was a strike. It falls within the meaning of the term under the labor code. There was a stoppage of work, and you did that for economic reasons. You were protesting the alleged unlawful withholding of your salaries and other economic benefits. It is the substance of the act that is determinative of whether it is a strike or not. Not what the way you wanted to call it to be. It is the substance of the act that is determinative of whether it was a strike or not the way you wanted to call it to be. Besides, sabi ng Supreme Court, you were not punished for exercising a constitutional right. You were punished for conduct prejudicial to the best interest of the service. You walk out of your classes during regular class hours, and you refused to return to class notwithstanding the order from your superior desk. And as a consequence, the pupils were prejudiced. Had you done your thing during recess, or out after class hours, or during Saturdays, Sundays, holidays, nobody will penalize you for that. But you did that during regular class hours, and you refused to return to class notwithstanding the order from your superior. So as a consequence, the pupils were prejudiced. So you were not punished for exercising a constitutional right. You were punished for conduct prejudicial to the best interest of the service. You get the point? Jacinto versus Court of Appeals. What you did was a strike, although you deny it. It falls within the meaning of the term strike under the labor code. There was a stoppage of work, and you did that for economic reasons. You were protesting the alleged unlawful withholding of your salaries and other economic benefits. It is the substance of the act that is determinative of whether it is a strike or not the way you wanted to call it to be. Okay, Jacinto versus Court of Appeals. So we'll continue from there.
Mm-hmm.